We have one case on the docket today. It's Capital Health Plan versus Timothy Moore. Counsel, if you're ready, you may proceed.
Good morning, David Shelton on behalf of Capital Health Plan. I'd like to reserve 3 minutes for rebuttal. May it please the court. In this age discrimination case, the trial court was persuaded to make an erroneous construction of the relevant statutory language. The relevant language is that Dr. Moore had to prove his age discrimination, that he was discriminated against because of his age. And that language has been construed by the United States Supreme Court in the Gross versus FBL case to mean that it has to be but for causation in order for the plaintiff to prove their case. And in the Gross case, they were reviewing a jury instruction, which was very similar to the jury instruction we had in this case, in the sense that in that one they allowed age to be considered only a motivating factor in the result. And they explained in the jury instructions there that a motivating factor was if it played a part or role in the decision. And the court rejected that and said it has to be more than that. It has to be the but-for causation. The age discrimination has to be the reason why the decision was made.
Counsel, I didn't get the impression that you and plaintiff necessarily disagree on that. I think it's just a question of what but-for actually means. My understanding of the plaintiff's position is but-for simply means that it's the determinative cause. Not that it's the sole cause, but that it kind of tipped the balance to what was in this case denial of employment. I mean, isn't it really? How is what you're saying necessarily different from that?
Well, the jury instructions that were given were very different than the structure of Your Honor's question. Your Honor's question suggested that but-for means it has to be the determining factor. The jury instruction said that it has to be a determining consideration that made a difference, not that it made the difference. And I think that goes to the heart of the problem, is that in the case, it can't be the motivating factor. It can't be something that that creates an incremental or contributing factor. It has to be the determining factor under the Gross case.
What would
and
you
that's
do?
the difference.
What would you do in the case where there are two but-for factors involved? Let's say that there is a situation where if you're late for work and over 40, you get fired. If you're late for work under 40, you have to make up the time at lunch, something like that.
That's the Judge Hinkle example that's in the record. And my response to that is I don't think there are two but-for causations in that example. The employee in that case is not being fired just for being late. They're being fired because they're late and they're old, because in that hypothetical, there are employees that are under 40 that also are late, but they're not fired. So it's not that they're fired just because they're late. So it's not an independent but-for causation. The only but-for causation in that example is that you are over 40, because all of the people who are late are not treated the same. The only difference in the treatment is because of the age, which is what Gross says you have to have.
And so is your argument is that there can only be in any given situation one but-for factor?
That's correct. And even under the case that they relied upon to convince the trial court to take an erroneous view of this language, the Burge versus U.S. case, that doesn't even stand for the proposition that you can have multiple but-for causations. In that case, it was a criminal statute, it had different statutory language, but they also said that language should be construed as but-for causation. But there was a question of whether the heroin that the defendant had sold was the reason why the person had died. And they ultimately concluded that they couldn't have a conviction under that statute, under that statutory language, because they didn't have evidence that the heroin was the reason why the person had died. Even though he had other drugs in his system, the point was you had to show that the heroin was the but-for causation. The heroin had to be the reason. So I don't think that you can have two but-for causations. And even the cases that we cite, there are cases from the federal courts where the plaintiffs claim age discrimination and some other kind of discrimination, such as race discrimination, and the courts say because of gross, because of the but-for reading of the ADEA, you can't have that, so that they dismiss the age discrimination parts of those suits, and they allow them to proceed on the race or the other kinds of discrimination.
What should I do about, or what part should the verdict form play in this? Because the jury made a specific finding in the jury form, it seems. It asked the jury, did you find from a preponderance of the evidence that Capital Health Plan did not award plaintiff the job because of his age? Because of his age, and they marked yes. So they made a specific finding that age was the reason.
But I think you have to look at the jury verdict in the context of the jury instructions, because the jury was specifically instructed that it wasn't necessary for Dr. Moore to prove that the age was the sole or exclusive reason. They were told that it would be sufficient if the age was a determining consideration that made a difference. And that's the problem, is that our whole case was we had these legitimate reasons for the decision to promote one doctor over the other. They didn't meet those legitimate reasons head on. They asked the jury to ignore those. And that's really what Gross suggests, is that you really need to have a one or the other situation, either to show that those reasons are pretext, meaning that they are false, they are not the real reasons, and that age discrimination is the real reason. But this jury wasn't tasked with that question.
Well, let's pick up on exactly that. I think that, while we may agree that the one sentence that you pulled out, that whether age was a determining factor may be problematic, but the jury was later instructed, consistent with the quote that you had from Gross, that Dr. Moore was not promoted, quote, because of his age. And that was later in the jury instructions. So why doesn't that cure any problem that there was with the earlier language in the jury instruction?
Because the first language that I read explains what that second language means according to the plaintiff's theory of the case. And that's the problem. Everybody submitted, or at least initially they submitted the pattern jury instruction, which just had that language that said you've got to find because of his age. And it was the plaintiff who came in and said, we want to clarify that language. And so that's the reason why we're here, is because they said that language, that pattern language that comes from Gross, needs to be clarified. So that's the problem, is the jury couldn't just get the Gross language, the because of age language, without being told what it means. And what it means, according to the plaintiff, according to the trial court, was that it means it could be any influence on the jury, on the decision, and that's completely inconsistent with Gross. It can't just be making some difference or making a difference. It has to make the difference, and that's the problem. In the way I look at it, we had overwhelming evidence of the reasons why one doctor was promoted over the other, and they didn't meet those head on, which is what the case law says they have to do.
What do you say about the counter-arguments that the qualifications for this position seem to be shifting? Sometimes it was talked in terms of there are three things we're looking at in evaluating candidates, sometimes 5, sometimes 8, sometimes HR experience mattered, and
Well, I personally don't think that they are inconsistent, which is what the real question is. If they were inconsistent, I think I'd have more problem. The problem is that these three, or the problem for the other side's argument, is that these three have always been there. The idea of the interview being important, the attention to detail being important, and the staff relations being important, those are all throughout. It's not like they're in one but not in another where we have some inconsistency. They are always there. Maybe there's some other things. My view is that you should look at just those three, because the case law says that we could have many reasons, and they've got to basically shoot down each and every one of those reasons. So just saying that we have other reasons doesn't shoot down those three primary reasons. And I think the evidence is overwhelming with respect to the attention to detail. The question of attention to detail was remarked upon every year in the performance evaluations. It was a theme throughout the performance evaluations. It was something that was noted in the interview notes from both of the doctors, and that was the determining factor. If you look at the scores, one doctor scored 18 and the other doctor scored 16, and the only difference was the 2-point difference for attention to detail.
Counsel, I'm kind of curious about this because we have the shifting burden that requires proof of falsity. In your view, what would the plaintiff have to show to demonstrate that those reasons were false or pretextual?
Well, certainly the case law says they have to meet them head on and say that they're false. I don't think under this record that they could prove that because it had been ongoing. We go back all the way to the beginning of the performance evaluations that Dr. Moore had with CHP, and that was an issue there. So it's not something that was just made up after the.
So is it unassailable?
Under this record, I think it is. Under this record, I don't even think that the plaintiff attacked the attention to detail head on. He admitted that it was brought up every year. He tried to downplay and say that it wasn't mentioned in between the performance evaluations, but that's not meeting it head on. That's not saying that he didn't have an attention to
My
detail
recollection
problem.
is that that reason was given to numerous optometrists, and it wasn't really something specific to Dr. Moore.
Well, it was mentioned in other performance evaluations, but it was consistently, I think the point is that it was consistently year in, year out mentioned here, and I think that's the reason why it was a legitimate reason for the differential between the two doctors, and it's the reason why under this record, the plaintiff can't come in and show that it was false, and that the reason why the decision was made was because of discrimination, which is what they have to prove. And the way I look at it, the plaintiff was able to try their case based upon the theory that both sides' reasons could be true. And I think that goes to the fundamental error in the case, is that they can't both be true under the ADEA, because you don't have motivating factor. Under some other statutes you could, and you could say which one was the motivating factor. But here, you can't have them both be true. It's either because of this or because of age, and if you don't meet these other reasons head on and disprove them factually under the record, then you can't carry your burden with respect to the age discrimination claim. In my view, the record shows that this is nothing more than speculation on the doctor's part. This all started with respect to an email that he sent, and he says, "I can only assume." And I don't think that the evidence at trial was anything more than assumptions or speculation on his part. We certainly would ask the court to clarify that the standard of the law in this case should be the gross standard, should be but for, and that the trial court got it wrong with respect to formulating the theory of the law of the case, and that affected not only the jury instruction, but also it affected the trial court's ruling with respect to the motion for judgment as a matter of law, because she didn't evaluate the evidence in the gross standard. And so we would ask that not only that it be reversed, but be remanded with directions for entry of judgment in our favor. I'd reserve the last few minutes for rebuttal. Thank you.
Thank you, counsel.
May it please the court, I'm Rick Johnson, Tallahassee, Florida, for Dr. Moore. I think something that is a threshold issue was not covered in my worthy opponent's presentation, and that is this, that there was a trial and Dr. Moore put on all his witnesses and he put in all his documents and he rested, and then it came time for the defense to present their case, and they stood up without presenting even one witness or introducing one document, and they rested. They didn't put on a case. And so now they're here, and the standard of review is what is commonly called in Florida law competent substantial evidence. And I cited a whole plethora of cases in my brief that say that what that means is that if there's even a shred of evidence, even a scintilla of evidence, if there's anything at all, then the verdict stands. If anything,
What is that evidence? We've heard that year after year that attention to detail was a problem for your client, and that was the reason that they gave for not getting the job here. What overcomes that?
well, I think that, probably the biggest thing was that there was some evidence that Dr. Adamson had as much or more problem with attention to detail as Dr. Moore did, and that it was maybe not noted quite so frequently, but that it was of matters of greater importance, and that she had not had the kinds of experience that would educate her in what the importance of those details were. So what it came down to was a jury question of weighing the evidence. There's some evidence that attention to detail was a problem for Dr. Moore. There's some evidence that there was enough attention to detail problem for Dr. Adamson that the jury could have decided that that was not really a factor that was taken into account.
But
Was a
doesn't that
pretext.
underscore the challenge with this particular jury instruction? When the jury was instructed whether the age was a determining factor rather than the determining factor, why wasn't that misleading? And of course, we review that under an abuse of discretion standard.
Yeah, and I think what you want to do with regard to that is look at the barrage opinion by the Supreme Court, because what Justice Scalia does in that opinion is he goes down that very language, a factor and the factor, and he makes sure that you understand. And these are the cases he's discussing there, Gross and Nassar, the ones that they're relying on. And he changes the language from the factor to a factor in that opinion. And then he goes on to explain that there really is virtually no such thing as a sole cause. There is, for example, he gives the example of the straw that broke the camel's back. There may be 1 million straws that it takes to break the camel's back. Every one of those 1 million straws is a but-for cause, because if you take it away, the camel's back is not broken. That is where they're getting confused on the appellant's side with looking at language that Gross overturned about a determining factor versus a motivating factor. A motivating factor is not good enough because a motivating factor could be a small percentage of the causation in the case. A determining factor is one that tips the balance. We explained that in the brief, and then they came back in the reply brief and said we're doing gymnastics, and they made it sound like it's voodoo. But it's really a pretty clear and important distinction, because what the distinction is, it's a motivating factor if it's somewhere present in the decision, but not enough of an influence to determine the outcome. A determinative factor, and with a motivating factor, the same decision would have been made.
Well,
with or
how would the
without.
jury have understood everything that you've just said from this instruction?
Well, I don't think that the question of motivating factor would have even entered their mind. At least it shouldn't have, because when they say determinative factor, I think anybody who has a basic high school education would know that a determinative factor is one that made a determination, one that tipped the balance, one that actually made a difference, that had an influence. I think that the way that we use the word determine, determining, determinative in ordinary English is not something that it only becomes a legal issue when there's a lot of money at stake and people have to hire advocates to make arguments, but that doesn't happen in the life of an ordinary member of the jury. And this stuff has all been so thoroughly vetted, so thoroughly decided from the Supreme Court on down that there just really isn't room for disagreement anymore after Barrage, which analyzed Gross and Nassar in such meticulous detail. I wanted to talk a little bit about the other issues. If I don't know if we consider them abandoned because they weren't raised in oral argument, but there was a question about the front pay. And the assertion was that the front pay has to be in some sort of an egregious circumstance before you get front pay. That's wrong, because the egregious circumstance doctrine only comes into play where the employee, the aggrieved employee, has been offered the job and turns it down. Then they have to show an egregious circumstance.
Well, Counsel, what does it mean in that context? If you have, I understand we're talking about a different context than what we have here. Somebody who doesn't get hired and for whatever reason they can't be hired, what makes something egregious?
I think the egregious circumstance is that the employee has been offered the job and turned it down. And in that case, the employer conduct has to be so outrageous that coming back to the job that was offered is going to ruin the mental health of the employee. So they would have
So otherwise, they don't get front pay.
if they are offered the job and turn it down, and they don't have a good reason for turning it down.
Was that part of the discussion here about bumping, I guess, the incumbent out of the job and putting your client into it?
No, because there was never a motion to do that, because to displace an incumbent, an innocent incumbent, is such an extraordinary and rare circumstance that our side didn't even ask for it. Asked for front pay in lieu, and they could have offered, I mean, if the judge wanted to impose the job, or say the next time the job comes open, Dr. Moore will get it, or the next comparable job that comes open, Dr. Moore will get it. But what she did instead, Judge Gevers, was basically a surgical implementation of a remedy, so surgical that I would have thought that an organization like Capital Health Plan would have an appreciation for it. They are, after all, a medical facility. But the surgical thing was to prevent a windfall by awarding a lump sum for 5 years or however many years. And what she did instead was to award $10,000 per year for as many more years as he worked. And then, so there was no chance of him getting a windfall. And there was no displacement of the incumbent. It was just really kind of the best way to resolve the thing without doing any harm or violating any of the principles. Now, this reasonable attorney's fee, I was kind of taken aback by that, because I had already seen that part of the brief where they where they said we had zero evidence, and then they spent 20 some odd pages arguing with the evidence that we didn't have. And then I come down here and they say that we had no evidence of Mr. Garrity's and Ms. Maddox's attorney's fees, no evidence. And there was no mention in there of Judge Walker's 36-page discussion in the transcript of
Did the
why
defendant get an opportunity to cross-examine Judge Walker?
No, but, we don't really do that in fee.
Of course not.
In
Is
fee
Judge
proceedings.
Walker an expert in fee litigation matters?
Certainly he is.
Well, then, he wasn't a witness in this case, obviously, which is why they didn't get to cross-examine.
No,
Why
but,
do,
yeah, I mean,
why is it proper to rely on Judge Walker to establish the fees?
Well, I submit affidavits all the time, and my credentials are less than his. Nobody cross-examines me. Once in a blue moon, somebody might take my deposition, but they didn't object to the absence of any kind of an expert, and they didn't object to the admission of the transcript of Judge Walker's disquisition from the bench.
Well, even taking that at face value, what in the record would support a $650 an hour award in a single-issue age discrimination case tried in Tallahassee? What in the record would support that award?
I think the thing that would support it most would be Judge Walker's discussion of attorneys of comparable skill and experience to Marie Maddox and Jim Garrity getting $1,200 an hour in his court, being awarded that, and others being awarded $750. So I think that's the best thing, and the greatest evidence that you can possibly have in a fee petition is what has actually been awarded by other judges in other courts. And here we have the actual judge who is awarding these amounts in his own court, telling us in a transcript what he's giving to other people. And he mentions their names and he mentions their fee amounts. So I thought that was compelling. I have nothing further.
Are the cases wrong that require expert testimony?
I'm sorry.
Are the cases wrong that require expert testimony on what's a reasonable fee?
Well, they only require expert testimony if the other side has demanded it. That's not a non-waivable requirement. If they had asked for, if Capital Health Plan had asked for expert testimony, they could have got it. Jim Garrity gets expert affidavits from me and a number of others all the time when it's required or where it's called for. Thank you very much, Your Honors.
Thank you, counsel.
I want to address the substantive claims. The suggestion was made that the historical evidence of Dr. Moore's lack of attention to detail should be ignored because there was some similar complaints or criticisms lodged against the other applicant. That's just not part of the record, Your Honor. I would direct the court's attention to page 1010 of the record, where Dr. Adamson's evaluation says does a great job with documentation and EMR, electronic medical records, and timely completion of records. Another yearly performance review is in the record at 1018. It says the same thing. Marissa does a great job with EMR, providing good documentation and timely comparison. So I think that should not be considered by the court. What should be considered by the court is the appellee's argument with respect to Burrage. We just fundamentally disagree with what that decision stands for. The case dealt with a situation where the person had smoked marijuana, taken oxycodone pills, and injected heroin. And one of the doctors said that the heroin was a contributing factor. It contributed to the overall effect that caused the death. And the court said that was not enough, that even under that standard, that criminal statute, which said results from requires but-for causation, and the doctor's testimony was not enough because they didn't prove that the heroin was the reason why the person had died. And that's the same problem that we have here, that they can't prove that the age was the reason when you have all these other legitimate reasons which weren't attacked head-on. And it's not enough for him to come in and say we made a mistake and that we should have considered Dr. Adamson's lack of attention to detail, which doesn't exist in the record, because it's not a matter of mistake, it's a matter of discrimination. If they can't prove age discrimination, they haven't proven their case. Thank you.
Thank you, counsel. Thank you both. This concludes our docket for today. However, the court will remain in session to take questions from students from the Florida State College of Law. And counsel, you may join us if you wish, but if you need to leave, we understand that as well. Absolutely, Professor Taylor, we would welcome that. Okay, for the audience, this is a group of students who are pursuing their LLM degree at the Florida State University College of Law, and we've agreed to stay on the bench for a few minutes to answer questions they may have about judging, about the First District Court of Appeal or the practice. So with that, don't be shy and feel free to approach and ask questions.
Thank you for having us. I guess I'll kick us off with the first question. How frequently does the court grant oral arguments?
Okay. Judge Osterhouse, you want to take that one?
Sure. In most cases that we have in the court,